Here, Your Honor.
That's from Zip.
What?
That stuff's from.
Oh, yeah.
Those are your copies.
Okay. All right, we are present in case 25 CV806. Case is captioned Jorge Orozco as the administrator of the estate of, I'm going to mispronounce it, Nayeli? Nayeli Orozco versus Elizabeth Matovich. We're here for a damage hearing, the court having previously granted the plaintiff's motion for default judgment. Plaintiff is present, represented by attorneys Mark and Matthew Zuccarelli, and the defendant is represented by Mr. Walter Krongold. All right. Mr. Zuccarelli, are you prepared to go forward? Proceed.
I am, Your Honor.
Go ahead.
Okay.
Sorry.
Your Honor, we're here for the death of a 20-year-old girl. My client's sister, he's the duly appointed administrator of her estate, killed by a 49-year-old lady who pled guilty to aggravated vehicular homicide as well as OVI. Now, I believe, and I have an expert that will put the value of her lost wages at $862,000, and I'm going to go through that. I believe not only should this be a compensatory damage case, but this should be a punitive damage case. And I just want to go through the history of this a little bit. You know, it angers me, to be honest, that somebody would file a motion to vacate a judgment where a client has pled guilty to an aggravated vehicular homicide, because as this court denied it, there was no justifiable defense. But of course, that necessitated attorneys' time to file that, and that's why we have filed it. And I know the court has to set that for hearing, and it's not today, but an attorney fees for frivolous conduct, as well as the fact that the court, under punitive damages, can award attorney fees. So there's no way you can have a meritorious defense to that. You can certainly argue, as we are today, that the case is not worth much money or whatever, and I don't know how you even argue that when you have a 20-year-old girl who was in her second year of nursing school, full-time and working part-time. How we're here on the damages here. But I'll move on from that. This accident happened on December 4th and 24th. We have a judgment, and under the wrongful death statute, I have the father here, who is under 2125-02A, rebuttably presumed to have suffered damages. Obviously, I have the executor here, the administrator here, who's the brother. You will hear that she had two other brothers. And the damages we have, you're going to see that we have funeral expenses. We have exhibits here of funeral expenses. You'll see that that is number 4 and number 5. The funeral expense in the cemetery was $25,534.
That's 4 and 5 together, correct?
All together, yeah. The monument was, and I'm sorry, since I had my eye surgery, my close vision, so that's a good thing. If you take a look at Exhibit 4, you will see that the monument was $8,603. The funeral expense was $16,250.43, and Exhibit 5 is the cemetery lot for $300. Now, see, Mr. Krongold argued that that was ordered as restitution in the criminal case, which is all well and good, but I just was presented this morning with a receipt that my clients paid that amount of money. So I haven't marked it as an exhibit because I just got it. But they paid Bain Funeral Home $16,250.43 on 12/16/24. It was paid by the decedent's mother, and unfortunately, she will not come here to testify today because this is just too traumatic for her.
Excuse me, I don't mean to interrupt, but do you have any of the filings that you gave the court? Do you have a copy for me? Because I haven't gotten anything.
I wasn't going to give you anything because I told you if you filed this, I was going to do everything that I could do legally. But as soon as I introduce them as exhibits, I will be happy to give them to you. I would like to indicate that after you consider the factors for the wrongful death statute, that this is a punitive damage case. I don't think that there's any doubt about that. Now, I heard Mr. Krongold in one of his briefs to this court indicate to this court that, and he agrees with me, we have to show that she owned the title to the car or suffered, or she was alive in order to get that. That's the Supreme Court case of Rubik versus Hoffman. What's puzzling to me is that in his brief he indicates that he would not concede that she owned the car. And not only am I going to show you the title, but what's puzzling is his company, State Farm, and you're going to see it's the same VIN number that they looked at that same car and offered to pay money on that car. So obviously, as of June 4th, 2025, State Farm knew she owned the car because they were going to pay for it. And I find it incredulous that somebody would file a brief saying they didn't know she owned the car. That puts us into punitive damages. And then his last argument that I'd like to address at this point is that the punitive damage statute does say that you can do up to 2 times the amount of compensatory, or it can be limited the lesser of 10% of her net of what she's worth. Now, what I'm going to say is, first of all, there's a supplemental motion filed by the Mr. Kronkold, and that supplemental motion indicates, as I'm trying to find it, the supplemental motion indicates that, I'm sorry, supplemental motion indicates that she's got an affidavit in there, and her affidavit, which I would argue since I can't cross-examine her, in her affidavit, she indicates that there's a value to the house. She doesn't own the house. Her father owns the house because we have a case for fraudulent conveyance. So she's not eligible to testify as to value because she's not the owner. But more importantly, she lies in that affidavit. Page 2.
Which exhibit is the affidavit? I have.
This is a supplemental.
I have that right in front of me. I just don't. There's.
It's the affidavit of the
All right,
defendant.
let me see which exhibit that is going to be.
Exhibit A. I'm sorry.
It's Exhibit A.
Yeah. He says
Oh, I got it. All right.
So,
Good.
it's got the value of the house, which again she can't testify to. But if you take a look if you take a look at the second page of that affidavit, she says, "I have only paid $1,000." And I'm sure she didn't put the affidavit. She put that number in there. The problem with that, Your Honor, is you're going to see Plaintiff's Exhibit 12. Plaintiff's Exhibit 12 is in your court. That's the other case where we have sued her and her father. Now, fortunately, the father, in his answer, attached all the checks that she wrote to him. And those are $9,000 worth of checks, not the $1,000 that she said. So, again, the type of case where we have a defendant, and I don't know, I don't want to besmirch anybody, but certainly the insurance company has fought very hard to try to say that she doesn't have anything and that she lied. You're going to see the evidence she lied in here, so we think that as far as punitive damages, that the 10% of her, 10% of what her value of her
Net worth?
Yeah, her net worth, that you wouldn't have any testimony as to that, and whatever testimony you have is false. So, at the end of the day, Your Honor, we are going to ask, we have, again, an expert who's going to suggest that her loss, financial loss, and I've not seen this. I think he did a good job, because not only did he say over her period of life she would make $2,400,000, he also says over her life she would have spent this much money. And you're going to hear from the expert very soon, Dennis Medica, that her lost earnings are $862,137. And I believe if you look at the rest of the factors having to do with loss of society, companionship care, and the other factors under 212502D1 through 5, that I think, her life's going to be worth $1 million in compensatory damages. I don't think it's unreasonable to add another $138,000 for this girl's life. She lived at home. You're going to hear good things about her. Whenever the court's ready, I'll present my first witness. And again, it's difficult to present some of these because she's deceased. So I don't have her to come say, here's her title of her card, because she's deceased. So I can have my client, who's the administrator, if the court wants her.
Thank you. Mr. Kronko, I'll let you make any opening remarks, but I do want to make it clear that we're not here challenging any of the facts of the case, because this is a default hearing. Default was granted, so what was set forth in the complaint are the facts. What was set forth in the complaint was that she experienced pain and suffering. You know, you're contesting that now, but and you attached to give me an affidavit, but that's not relevant for this purpose. We're not going backwards. What was set forth in the complaint, I granted default judgment to, and we're not going to now say that those facts aren't true. So I'll let you be heard here.
Thank you. Your Honor, in the beginning, Mr. Zuccarelli had stated that I filed a motion to vacate for some spurious reason. I had talked to my client about presenting about the damage hearing. I asked her, said we're in default. The hearing will be before the judge. You do have a right to a jury trial on default damages. I think there's case law to support that. I asked her, which do you want? You may not come out any better one way or the other. She said, I prefer to have a jury trial. That's why I filed my motion to vacate, to give this woman something she's allowed to under the law, and that's a jury trial on damages. I'm not contesting the fact that she's liable for this accident. I'm not contesting.
I don't know if that's true. You're entitled to have a jury trial for default for damages under certain circumstances. I had one last year, a big trial, but that was because the person answered. We had a case that was going on forever. They didn't do anything during the case to defend the case. They never complied with any discovery. They never did anything. I put multiple orders out saying, I'm giving you one last chance to do this, and if you don't, I'm granting default judgment against you. They didn't. I granted default judgment against them. So then went to a damage hearing, but they had participated in the case up at that time. They made a jury demand with their answer. Under those circumstances, you're entitled to a jury demand. I'm not going to sit here and say for certain under the facts of the circumstances of this case, but I don't believe under the circumstances of this case that would be the case. But go ahead.
Your Honor, I'll be happy to supplement these arguments with some case law. Regarding the punitive damages, I had never seen a title of the car. Of course, Mr. Zuccarelli is very clear he wasn't going to give me a single piece of paper until we got here, and so had he bothered to send some of that information to me, it may have expedited things. If he's got a title of the car, then they can show property damage under the survivorship statute. The pain and suffering aspect doesn't matter, and he may be entitled to punitive damages, but again, he's never bothered to give me anything. As far as the caps go on punitive damages, Your Honor, I think that please understand, Ms. Madovich is in prison. She has really nothing, no access to anything. Her affidavit was given to me. I prepared the affidavit. She filled in the blanks. It was based on the best of her knowledge. Now, when she paid the $8,000 to her dad, I don't know. I don't have any of that. She was making the best estimate. I don't think there was anything fraudulent about the
This affidavit was
It was recently.
Yeah.
Yeah, but she didn't have access to anything, any of her records. She's in jail. And
She
again,
should have said, I don't know. I mean, I don't.
well, I think she made a best estimate, Your Honor. She made a best estimate as to the value of the house. And I think she's entitled to do that. And based on that information, that's why I put the $74,000 as far as her net worth. That was her best estimate based on the information she had available to her. Her father apparently is living in the house. He's the subject of the other lawsuit. I don't represent him for that. But she gave the best estimate she can. There is, as I explained in my brief, Your Honor, I don't think there is any basis for an exception to the damage caps. This isn't a crime of knowingly or purposely. She was convicted of vehicular homicide, second-degree felony. As I said in my brief, if the prosecutor thought she did something intentionally, he would probably charge her with murder, and he did not. As far as the funeral expenses go, Your Honor, my only point was she was already, the plaintiffs were already awarded that through the criminal action against his manager. There is a judgment against her for that amount. So I think giving her a judgment for the same amount, in this case, really duplicates damages, and plaintiffs could argue that you owe us $25,000 under the criminal statute, but hey, you also owe us $25,000 under Judge Culotta's order. So I'm just asking that damages not be duplicated, and there's already been an award made of $25,000 for funeral expenses.
Thank you, sir. Oh, I'm sorry.
No, and again, I don't know what evidence there'll be on the wages, but certainly I think under the jury instructions, that amount should be present value. I don't know if it is or not, but I think that's an obligation they have to present value that money. Thank you, Your Honor.
Thank you. Mr. Zuccarelli, you can call your first witness.
Your Honor, based on what I heard, I'm going to call Mr. Krongold to the stand. Normally I wouldn't do that, but
I would object. I mean, I'm an advocate for my client.
I'm not going to do that. Let's just
Okay.
call your next witness, please.
all right. Your Honor, I would call Dennis Medica.
Medica?
Good afternoon. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Let's see.
You know what this? Yeah. Good morning, or good afternoon, Mr. Medica.
There you go, sir.
Could you state your name and business address for the court, please?
Certainly, Dennis Medica, 815 Superior Avenue, Suite 1916, Cleveland, Ohio, 44114.
And, Mr. Medica, what's your business occupation?
I'm an accountant focusing on forensic accounting and fraud investigations primarily.
Okay. And do you prepare reports for parties to use based on present values?
I do, and I have.
And how many of those have you done, sir?
Over my career, it's probably been hundreds. I don't recall
Move up to
exactly.
the microphone just a little bit, please.
Sorry. It's probably been over 100. I don't recall the exact number.
Have you testified before?
Yes, I have. I've testified both in federal court and state court in the past.
Have you been qualified as an expert witness to give testimony concerning present value?
Yes, I have.
And we would ask the court to so qualify him as an expert.
I'll take his qualifications into consideration here.
Okay. And let me just go through it just to make sure. And what's your educational background?
Certainly, I received my undergraduate from John Carroll University with a major in accounting. Thereafter, I received my Master's of Business Administration from Cleveland State University, where I also teach as an adjunct professor and have since 2013.
Okay. And what professional affiliations are you a member of?
I'm a member of the American Institute of Certified Public Accountants, the Ohio Society of Certified Public Accountants, the Association of Certified Fraud Examiners, the American Bar Association, the Cleveland Metropolitan Bar Association, and many others.
Okay. And what's your professional work experience? Could you go back and tell us what you've done?
Certainly. After graduating from college, I joined an accounting firm by the name of Walthall and Drake, and I was there from 1991 until 1995. And I served as a accountant providing audit and tax services to clients. After that, I joined Aetna Plastics as an interim controller for a period of time, and then thereafter joined Card Palmer Citizen, which is a Cleveland accounting firm, as a supervisor in their tax and audit department. In 1998, I joined PricewaterhouseCoopers, which is a global accounting firm focusing solely on fraud investigations and forensic accounting matters. And that has also led me to testify in various matters in my role employed at PwC. In 2009, I formed Medica LLC, which is a boutique forensic accounting firm focusing, as I mentioned earlier, solely on or primarily on forensic accounting and fraud investigations. We also provide business valuation services and tax counsel to clients. A number of those projects that I've been involved with has led me to testify both in federal court and state court, as I mentioned before, in civil and in criminal matters.
Have you had any publications, sir?
I have. I've had numerous publications published in the American Bar Association Journal, the Cleveland Metropolitan Bar Association Journal, and a number of other professional journals.
Have you made any presentations in your profession?
I have. I have made presentations or lectured at CLE programs at the Cleveland Metropolitan Bar Association at various programs there. And then also I have been invited to speak at various law firms on topics of damage quantification in their in-house CLE programs, among other presentations.
Now, in front of you is Plaintiff's Exhibit 10.
Yes,
Is that a report that you authored in this case?
it is.
All right, before we get to that, if you go to the back of this report, Exhibit 7 has your qualifications, and rather than go through all of these, your professional experience, but after that it talks about the cases that you testified in.
Correct.
Is that accurate?
It
That
is.
would be page 17, Judge.
It is, yes.
Those are the cases that you testified in?
Correct.
And in those cases that you testified in, were you qualified as an expert?
I have been, yes.
Okay. And on page 19, it talks, again, without going through all of these, those were the presentations that you have made as late as March of this year.
That's correct.
And then on page 20, these are the publications that you have authored.
Correct.
Those are accurate.
Yes,
This is part of your CV.
it is.
And then the page 21 deals with all of the certifications and professional affiliations.
Yes,
Is that accurate?
it is.
Your Honor, again, based on all of that, I would move that he be qualified as an expert. Mr. Medica, can you tell the court how you came to be involved in this case concerning Nayeli Orozco?
Certainly. I believe I may have gotten a call from or an email from yourself asking if I may be able to assist in this case and assess claim damages or claim losses that were incurred.
Okay. And can you tell the court what what you reviewed or what information you knew concerning the deceit?
Certainly. And for the court, there is a reference of the documents I relied upon as Exhibit 1 to my report, which is on page 9. I reviewed the complaint in this matter. There was an affidavit issued, and I won't go through this in detail, but there was an affidavit issued by Mr. Orozco. I did review also the obituary of the decedent, her tax returns and W-2s to form a basis for her historical compensation, and then also performed a review of relevant publications to determine losses in this case.
Okay. And what information were you aware of concerning her background as to how this case arose? As far as the date that she passed away, you were aware of that?
I was. I believe you may have shared that with me verbally, and that was evident in her obituary and also evident in the complaint. So as far as the background, my background was obtained through the complaint and conversations with yourself in that regard.
Now, you ultimately prepared a present value as to her lost earnings, is that accurate?
Ultimately, yes.
Okay. And was she in school at the time?
My understanding was she was a student at Kent State University in the nursing program, yes.
I'm going to hand you Exhibit 6, which is a transcript from Kent State nursing program. Does that help you recall that she was in her, second year nursing program?
That appears to be the case.
And then I'm going to hand you what's been marked as Plaintiff's Exhibit 7. That's a 2023 tax return from her.
Yes,
Did you have a chance to review that?
I have.
And then hand you what's been marked as Plaintiff's Exhibit 8, which is a 2024 tax return for Nayeli Orozco. You have a chance to review that.
I have.
And then Exhibit 9, which are W-2s from 2024 from Ms. Orozco. You have a chance to review those.
Yes, I have.
Now, in addition to going to the Kent State nursing program full-time, were you aware that she was working part-time?
My understanding, she was working part-time while going to school full-time, yes.
And in your report on page 2, you reflect where she was working.
Correct.
I'm sorry, page 3.
Correct. I was just flipping to that. I apologize. On the bottom of page 3.
So she was working for, she was working in the walk-in urgent care clinic part-time?
Correct.
And those W-2s reflect that you saw?
Yes.
And she was also working for her parents, correct?
That's my understanding, yes, for Suhas LLC.
Which is a Mexican restaurant in Madison.
Understood.
Okay. Now, did you, in coming up with your present value, did you provide an income or use an income as your basis as to her lost wages over her life?
I did.
Okay. Can you tell the court the number that you used and how you came up with that?
Certainly. I used $79,600 as an annual base plus 10% for fringe benefits. And that was derived from There was a study that was conducted by ZipRecruiter of compensation of...
What? Oh, compensation. I just didn't hear the word. You said compensation.
Correct. Compensation for registered nurses in Ohio. And that was, and $79,600 was the base median compensation. The other thing that I did do to corroborate that or get a sense of the reliability of that was to also go online, and I did note there were a number of openings at the Cleveland Clinic for entry-level registered nurses in Euclid, Garfield Heights, and also Cleveland. And those compensation amounts were approximately $90,000 on average. So I certainly used a number that, in my opinion, was conservative for purposes of calculating her lost earnings. And that was the basis for the compensation number I used.
And how did you derive at her life expectancy?
That was based upon the actuarial tables that are readily available. I specifically used the Center of the CDC's actuarial tables that indicate ultimately life expectancy. And based upon that, I calculated what her earnings would have been over her lifetime until full Social Security retirement age of 67.
And according to your report, at the time she passed away, she was 20.17 years of age.
Correct. That's on page 3 of my report.
Now, your report indicates that since she was a sophomore, that she wouldn't graduate for 2 more years, till 28. Did you use $79,000 as income while she was going to school?
No, I did not. I used her actual income prior to, while she was going to school, which was approximately $12,000 or $13,000 per year. The $79,600 in my calculation commenced in October of 2028. And that would have provided her sufficient time to graduate, obtain her registered nurse license, and seek employment opportunity.
And your report indicates that, why did you use October if she would have graduated in May? Again,
to provide sufficient time for her to study and take the registered nurse exam and to seek employment. I approximated that period based upon Kent State University's website that indicates that within 6 months, 90+% of graduates receive full-time employment after graduation.
Based on the annual compensation rate of $79,600 commencing in November of 28 and using the Social Security retirement age, did you come up with her lost wages?
I did, and it was October of 28.
I'm sorry. Did you come up with a value for her lost wages?
Yes.
And what was that?
Considering fringe benefits, and this is evident in my Exhibit 2, considering her fringe benefits, her total earnings, and considering the compensation that she earned prior to or while she was a full-time student, her total earnings over her lifetime would have been $3.8 million, or $3,828,635.
Say that one more time, please.
$3,828,635, as indicated on Exhibit 3.
What page is that?
Page 12.
I see it, page 5.
12?
Yes, page 5, Your Honor.
Oh, I'm sorry. Also on page 5.
Okay.
Now, you didn't stop there. You discounted that, did you not?
I did.
And can you tell the court why you discounted that number?
I discounted that number to consider the probability of employment and also life expectancy. Life happens, so the reality is people get laid off. People may be off work, they may be raising kids. So my calculation considers the probability of work during that period. So that number was reduced to $2,400,000 $547,964.
And how did you come up with that reduction? What did you base that on?
That was based on the likelihood of life, for lack of a better term, and the probability of employment based on data that's publicly available.
Okay. So now we're down to 2.547964, correct?
That's correct.
Now, you don't stop there, do you?
No, there was an additional reduction to arrive at the economic loss that were suffered.
And what additional deduction did you have, Mr. Medica?
A deduction for personal consumption, and that includes things such as housing, clothing, food, utilities. So those items were deducted from the number we just discussed earlier.
And after deducting those numbers, did you come up with a loss of earning number?
I did. Ultimately, the economic loss of earnings that I came up with was $862,137.
Well, let me just back you up because I think we missed one. After you took off the consumption, did you come up with, the consumption took that number down, correct, to 862?
That's correct.
And is that based on present value?
It is.
Okay. And
So the consumption was the difference between 862 and the 2.5 million?
That's correct.
1.786, okay.
so your number, Your Honor, his number on page 6 says your total consumption was 1,685,827. Is that accurate? Mr.
That is
Beck?
correct.
So you don't just say, here's what she's going to earn, I'll throw a rate on it, and that's her present value. You discounted it for life happenings, and you also discounted it again for personal consumptions.
Correct.
Is that standard how you would do a present value?
That's a common approach generally accepted in these types of matters, yes.
And is there a discount rate that you used in order to obtain present value?
The discount rate that's considered in here is approximately 3%. That discount rate is offset by an approximate 3% of growth in compensation. So in essence, those two negate each other. So inherently it's included in the calculation. But again, since it negates, there's no impact from a dollars and cents perspective.
Okay. And did you prepare this report that's identified as Plaintiff's Exhibit 10?
I did.
Your Honor, I have nothing further on Mr. Medica.
Thank you. Dr. Crandall?
Thank you, Your Honor. Good afternoon, Mr. Is it Medica?
Yes, sir.
I'm sorry if I mispronounced your name. I assume there's a charge for your preparation of your report, right?
My firm charges a fee, certainly,
What is
for the
that,
work.
please?
I'm sorry?
How much is that?
My hourly rate is indicated in the report, which is $3.95.
So it would just be a straight $3.95 per hour for whatever time.
Correct. And also, an associate did assist me, so her hourly rate also.
What is your total fee to date, including this testimony, sir?
I haven't issued an invoice for today because I didn't know how long that would involve. So prior to today, I believe it's $10,000 or $11,000 in total.
Okay. In your report, can we agree there's a certain amount of speculation in what Ms. Roscoe's future holds for her if she had lived? She may go in nursing, and that nursing career may have been interrupted or ended if she decided to help her family in the restaurant, if she decided to stop working and raise a family, and those occurrences are not that unusual in anyone's profession, right?
The probability of that, of life events, is considered in these calculations. As prior counsel indicated and I testified to, this analysis does include the probability of not working for periods of time, of layoffs and so forth.
Does it include the probability that she works for 5 or 6 years and decides to stop working and raise a family and not go back ever?
The probability includes all of those components.
So how does that factor in? I'm a little unclear, sir. How does that factor in into the reduction that you gave? I mean, there may be situations where she works her whole career, 5 years, 10 years, 15 years. How does the reduction take into account all those different possibilities?
The probability that's considered is from data that is produced and analyzed and provided by Statista, which is a data analytics company. And their study includes numerous instances, thousands of instances of employment probability. And that is the basis for this calculation.
Did you speak with the family at all as part of your investigation?
I did not.
Is everything that you've got through Mr. Ziccarelli, all the materials and so on that you reviewed in connection with your report?
Can you state that again, please?
Are all the materials that you reviewed received from Mr. Ziccarelli, or was there some other source of information?
All the documents that I relied upon are in Exhibit 1 to this report. There are data that I retrieved that did not come through Mr. Ziccarelli's office that I use in the calculations, but that is identified in my Exhibit 1 to my report.
Okay. The personal consumption that you talk about, what is, I know you indicated that it considers housing, clothing, food, and so on. Where is that information from?
The Bureau of Labor Statistics, and they published that study, I believe, sometime in 2025. And it's an extensive study. It breaks out consumption by income categories or income ranges.
Now you said that the present value of your $862,000 wage estimate would be offset by the growth in money, the growth in, or her expected increase in wages over time. Did I understand that correctly?
Can you restate that, please? I want to make sure.
You said that the present value that you would normally calculate would be offset by the increase in wages over time.
Ultimately, those two are fairly consistent. So yes, those would be offset.
Did you ever calculate the actual present value of the $862,000 in your report?
I calculated the average present value based upon the growth rate of compensation for the last 40 years.
Last how many years?
40.
Gotcha.
And compared that average growth compensation rate to the 3-month Treasury rate, which is in essence a risk-free rate for 40 years. And those two are fairly consistent at approximately 3%. So if you increase a number by 3% and then decrease it by 3%, you get the same number you started with.
Do you have those calculations, sir?
I do.
Can you please tell me what they are? Present value of her earnings and then the T-bill growth rate.
As I mentioned, the
So you're talking
impact.
about the present value without the growth compensation?
Yes, sir.
Can you restate your question, sir? I'm sorry.
Can you tell me the present value standing alone, that number of the $862,137 that's in your report?
As I said before, the present value has to consider those two.
I understand, but please answer the question. What is the figure you calculated as the present value?
Sir, if I may be able to complete, I'd appreciate it. The calculation of her compensation, to calculate her fixed compensation for approximately 45 years with no increase is not a reasonable approach of compensation. So as such, to calculate the present value of that fixed amount results in a meaningless number.
What is that number, sir?
I have no idea. I didn't calculate it, sir, because it's a meaningless number. It's not consistent with what her earnings would have been.
And do you have any idea what the wage growth would have been?
As I said before, historically, wage growth rates have been approximately 3% based upon the Bureau of Labor Statistics on average for the past 40 years.
But you never bothered to see what your exact number would be if you present valued her projected wage loss over the years to this present value now, right?
Objection, asked and answered.
Sustained. When you calculated this figure, you took the 79,600 as your starting salary.
Yes.
And then you multiplied that out over 40 plus years, including a rate for compensation,
For
growth
benefits.
compensation.
I'm sorry?
Include for growth compensation.
It,
So, and that's 70, what you're asking, Mr. Krongold, is a number, what the present value of 79,600 is times the 40 years, and the present value of that number, right? So you're asking, your question's based on her making her starting salary for the full 40-some years of her life.
Well, it was that, but also he said that I thought he said, Your Honor, that he calculated the present value of the 862, but then he found that that was offset by the increase in growth. And he compared the two numbers and they were approximately the same. So I was asking him, what are those two numbers?
Well, did you do that, what he just said?
as I said before, I didn't calculate an increase of 3% of her compensation per year and then decrease it by 3% per year for a present value calculation. It's a circular calculation, so I didn't do so. Inherently in my calculations, they do include a present value consideration.
Are you able to calculate the present value of the $862,000 one
That
at this
is,
time?
I'm sorry,
Are you able to calculate that at this time? The current present value of that $862,000 number?
that is the current present value of her lost compensation today.
That's all I have. Thank you.
Thank you. Redirect examination, Mr. Zuckerman?
Just a couple to clarify. When you calculated that, I see that you have Exhibit 5,
Yes,
and that's the average wage growth based on the last 40 years
it is.
that you talked about.
It is.
And based on, and again, for the judge, where did those numbers come from?
This came from the Social Security Administration.
And over the last 40 years, wages grown 3.75.
On average, correct.
And the next page, which is Exhibit 6 of your report, that would be the average Treasury bill, which is 3.19.
Correct, and that is what would be the discount rate, and those two are in essence the same.
And so if I understand correctly, basically what you did is you said she makes $79,000, multiplied it by her life, and you did not give her any growth. So basically for the rest of her life, she never made more than $79,000.
Correct in this calculation because that growth is offset by the discount.
Exactly.
Well, actually, the growth's more, though. I mean,
It's actually-
Slightly more.
it's still a little bit. So if anything, if you were to actually use the specific number, it would be a little bit higher.
It will be. And these are estimates. They're
I get it, I
approximations.
understand that, but
Yes,
just based on the 40-year average.
correct.
Nothing further.
Recross examination?
No, sir.
All right, sir, thank you very much.
Thank you.
Thanks, Dennis.
Mr. Zuccarelli, any further witnesses?
Yes, Your Honor, I would call,
Mr.
he's listed as Jorge, but he goes by George.
Okay. You can come up here, sir.
Thank you.
You stop it for 1 second, have you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, and that's on wheels, so be careful there. Just, get up by the microphone and keep your voice up, please.
Thank you.
All right, Mr. Zuccarelli, whenever you're ready.
Thanks. George, obviously the caption, and I'm just doing it for the record, is Jorge, but you go by George, correct?
Yes, sir.
And you are the duly appointed from the probate court of Lake County, the administrator of your sister's estate?
Yes, sir.
And for the record, can you state your name and address, please?
George Orozco, 10494 Johnny Cake Ridge Road, Concord Township, Ohio, 44077.
And George, what do you do?
I'm an insurance agent with the Knights of Columbus.
Okay. Now, and again, I'm sorry we have to talk about this, but we have to talk about your sister. Now, did your sister graduate from high school?
Yes.
And where did she go?
Chardon High School.
And what year did she graduate?
I believe that was 23. Roughly 22, 23.
After high school, did your sister have any post-high school education?
Yes.
And what did she do?
She was going to nursing school at Kent State to be in an anesthetic.
I'm sorry, say that again.
Anesthetic. It's an anesthesiologist nurse.
Okay. That's even more skilled than a regular nurse, right?
Mm-hmm.
You need to say yes.
Yes, she was wanting.
Okay.
Yes, she was wanting to help with the delivery of babies.
Okay. Now, what was your relationship with your sister?
My relationship with my sister was in our childhood rocky, but it was getting to a point where it was getting really, really good. She was taking care of my kids with me. She was. It was really good.
So, you have children?
Yes.
And today, how old are your children?
They're 5, 3, and 1, and I have one on the way.
One on the way?
Mm-hmm.
How old are you?
29.
And George, when your sister passed away, you said that she was helping to watch your children?
Yes, she would occasionally help us out.
Okay. And that's when you didn't have another babysitter or somebody else?
Mm-hmm. Yes.
And were you aware that your sister, besides going, strike that, Kent State, was that a full-time program?
Yes.
And besides going to Kent State, were you aware whether your sister worked after high school?
Yes, she worked at the Wild Burrito. For a time, she worked at an urgent care in Mentor, but she didn't continue there very long.
Okay. And that's you heard Mr. Medica indicated that she had W-2 income for both of those.
Yes.
And the Wild Burrito, that's a Mexican restaurant in Madison,
Yes.
and that's owned by your parents?
Yes.
So she would help your parents out there working?
Yes.
And besides yourself, did Nayeli have any other siblings?
Yes.
And who else was a sibling, George?
We have a younger brother, Eric Orozco. He's 2 years younger than me, 27. Just had his first kid. We have Ivan. He's graduating college this year. We have Mia. That's everybody in the States. And we have 3 other siblings in Mexico.
Now, where did your sister live?
She lived in Madison, Ohio, at my parents' address for 645 Madison, Riverwood Drive in Madison, Ohio.
All right, so she lived with your parents,
Yes.
and did she live there full time?
Yes.
And I know that her dad will testify, but what was her relationship with her parents that you saw?
They were always together. They were, in essence, since she was a little girl, she was the only girl in the household. There was 3 boys, so she was always with them, always her protector, even from us, when we were getting into fights and things. So they were always, whenever they would go somewhere, she was right there with them at all times, and that's how it continued through adulthood.
And your mother's not here today, is she?
No.
And how has your mother taken the loss?
It's been devastating to her. All growing up, she always told us that we were supposed to bury her and not the other way around. So this is really, quite literally, her worst nightmare coming to reality.
Now, it's been a while, year and a half,
Yes.
less than that, sorry, since this happened. Is the family still suffering for that?
Yes, absolutely, every day.
And do you know, and again, do you know what type of things that she did with your siblings?
Absolutely. So, for example, my mom is 46. She just had another child recently. That's why she's not here presently today. She's at home healing. She would have been there to help assist with that child and my other sister. She's about 6 years old, 1 year older than my most older son. So she was primarily her caregiver, actually, because my mom was always busy with the restaurant, doing things, helping with whatever. And she was always the babysitter. So that is no longer an option. So, and my sister is essentially sitting now in this big house, my little one, where it's just her and a baby and my mom, as opposed to a loving, caring older sister to help her guide her through whatever it is she would need growing up.
So your sister was a caregiver?
Yes.
And can you tell, did your sister provide any guidance or assistance to any of the siblings or family members?
Yeah, absolutely. My younger brother Ivan, he's 21 now. They've always been a year apart, and they were pretty much raised like twins. They were very much always kind of like each other's therapists, if you want to put it that way. She would provide them with my siblings mostly with guidance and help with whenever they were dealing with anything at home or with girls or whatever it was, style, socializing. She was very good at socializing. She was a social butterfly of the household. So all these kinds of things were things that she helped and assisted with, as well as the caregiving, driving to and from. She even drove me to the hospital one day because my wife was at work and I was throwing up at home and no one else could take me. And I called her. She was 5 minutes away.
And she took you?
And she took me. Mm-hmm.
Now, were there funeral expenses in this case?
Yes.
And I'm going to hand you what's been marked as, I'm just going to do them together, 4 and 5.
Thank you.
Now, I will agree with counsel that this was ordered as restitution in the criminal case of Ms. Matovic, but for the record, Exhibit 4 is the cost of the monument of $8,603
Yes.
for your sister.
Yes.
And then the funeral expense was $16,250.43.
Yes.
And again, I don't have this as an exhibit because you just gave this to me today, but did the family pay for that?
Yes.
And that's a receipt from, and you, is that a receipt from Maine Funeral Home that it's been paid?
Yes.
I don't have a copy of this, Walter. I don't have a
That's
copy.
okay. I mean, did you want to admit it as an exhibit? We make a copy of it.
Your Honor, I believe the bill itself says that there was a check that was paid, page 2 of the bill.
It does say that, but I just have a receipt now.
It does say total payments right on here. It says check 5329. Is that the check?
5329.
It's right on. It's part of
That's
your
fine.
exhibit. That's good.
Now, the other one, which would be Exhibit 5, that's the cemetery lot,
Yes.
and that was $300.
Yes.
Now, I'm going to hand you what's been marked as Exhibit 2, again, as the executor of the estate. Did your sister have a car?
Yes.
And that's Exhibit 2, if I didn't identify it, I'm sorry. And it indicates that the owner of this 2016 Jeep was Nayeli Orozco.
Correct.
That's your sister. She owned that vehicle at the time?
Yes.
I'm going to hand you what's been marked as Exhibit 3. That's at the top of that, that's a letter from State Farm. Do you see that?
Yes.
And that letter from State Farm is dated June 4th of 2025.
Yes.
And that has to do with Nayeli Orozco, your sister.
Yes.
Now, attached to that, Exhibit 3 indicates that they're going to pay so much for this 2016 Jeep Renegade, correct?
Correct.
And attached to that exhibit, when they come up with that number, is State Farm's vehicle valuation report, correct? You
Yes.
see those?
I see it here.
Now,
Question, Your Honor. I'm not sure he's qualified to talk about these documents.
I don't know if he's been asked that yet. He just asked if that's what was attached, but I mean, that question's overruled because he just asked is that what's attached, but we'll see where this goes.
I'm not asking for him to determine value, I'm just asking were those documents attached to it. Now, and on the front page, you see a VIN number?
Yes, it's right here.
And that VIN number is what?
ZACCJBBT5GPC89314.
And take a look at Exhibit 2. Is that the same VIN number?
Yes, it is.
So, at least in June of 2025, the insurance company in this case knew that your sister owned that vehicle, right?
Correct.
Sustained.
Based, at least from the document concerning your sister as the executor of the estate, you saw that?
Yes.
And you would have to approve that settlement for that vehicle as the executive, as the administrator of the estate?
Yes.
And that came to you in June of 2025?
Yes.
And that is the same VIN number as your sister's car?
Yes.
What else would you like to tell the court about your sister and what she meant to you and your family?
I would like to tell the court essentially the missed opportunities that I had and the regret that I have, because I will never be able to do anything about it now. When we were growing up, my sister and I had a really rocky relationship. We always butted heads. We were never even able to be in the same room, and I never thought that we were going to be able to get away from that or get past that. Well, thankfully I was wrong. When she was a young lady, she grew up to be an excellent young lady, and she was an excellent aunt. She had a lot of friends who loved her. She had a great relationship with me and my kids. It was always kind of awkward, but the last Christmas we had together, we were able to spend it with her, and we were in a brand new house that we never had. We grew up in a trailer park. Everything was looking up. Everything was looking good. The biggest Christmas tree we ever had growing up. So she helped us set it up. My brothers and I set it up while she took with the kids and everything. It was the first time where I had a special moment where I felt connected to her. I felt like, well, this is what it should have been growing up. I feel like especially now with my new sisters, I do puzzles with them. I do things that I should have done with Nayeli when she was younger. And I didn't, because I was fighting with her all the time.
What was your age difference?
She was 20. I'm 29, so about 9 years.
Well, you're 29 now.
Yes. Oh, but she was
20 when she passed. Right?
so 8 years. Yeah. Because I was 28 years. Yeah, so 28. I was born in 97. She was born in 04.
Okay.
And now I go to the graveyard and I tell her all these things like, hey, I should have been, you should have had kids, and I was going to take care of them the way you take care of my 3 boys. I was supposed to be Uncle George. I was supposed to see what, your kids look like, make fun of them because they look like you, and that's never going to happen again. It's never going to happen in the first place. That's what it meant for us to lose my sister. It was not only what she could have done, but what we had in plans with the family, with her, and what we never will be able to say and do now that she's not here to receive it.
And how often do you visit her?
I visit her at least once a month. I try to at least twice. She's right in Madison, so whenever I visit my parents, it's very easy to stop by at least twice a month.
I have nothing further, Your Honor.
Thank you. Mr. Krongold?
Thank you.
Mr. Roscoe, first of all, I want to say how sorry I am about the loss of your sister. This is a terrible tragedy for everyone, and even on behalf of my client, I have to tell you she's horrified about everything. If you would be so kind, I'd like to read you a few words that she has written to express how she feels.
Objection.
Sustained. That's not.
Matter, she did write a letter of apology to the Orozco family. I think at least he's...
This is not a criminal sentencing hearing or anything. This is... I'm sustaining that objection.
Mr. Roscoe...
And at this point, you're questioning... Go ahead.
Nayeli was living with your folks at the time of this loss, right?
Yes,
And where were you living at the time?
with my wife and kids in Concord.
How far was that from where your parents were?
It's 20 minutes.
Okay. It's a stressful period of time. I'm not saying that she was emotionally suffering or anything, but it's a stressful time because you want to do well in school. And it looks like she did do very well in school. Was her time with you and your kids limited around that time because of her involvement in school?
Yes.
So as far as maybe weekends or evenings, or if you needed help watching one of your children, she may not have been available only because she's tied up doing school activities or studying for her classes, right?
No, typically she would be during working out or school hours. She would be at school, but whenever she was like weekends or afternoons, she'd be available.
Okay. But when she was at home, she was also studying as well, right?
Yeah, she
Which
did
will,
homework.
of course, limit time that she may have with you or your children, right?
Yes.
You had mentioned a sort of a rocky start with your sister.
Yes.
And certainly all sorts of families have sibling rivalries or difficulties. When do you think things began to take a turn for the better with Nellie? And how old was she and how old were you?
I'd say when I was 18, she would have been a 10.
She would have been maybe 9 or
maybe
so?
9, something like that, yeah.
Was there an event that happened, or was it just sort of a coming of age for you and her?
I think it was just a coming of age. Like she started understanding why I did things a certain way, and I understood that she was a lot more similar than me than I thought.
Okay. All right, thank you very much.
Thank you. Any redirect examinations?
No, Your Honor.
All right, sir, you can return back.
Thank you.
I'd have Miguel Gomez.
Yeah, hallway?
He's out in the hall, yeah.
Yeah.
Judges for
I'll stop you there and have you raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? You can have a seat there. It's on wheels. Be careful. And just keep it up close to the microphone and keep it right so. It'll pick you up, all right? She's a bride?
Thank you, Your Honor. Miguel, can you state your name for the record, please?
Miguel Gomez,
And what's your address?
4645 Riverwood Drive in Madison.
And how do you know Nayeli Orozco?
I married with her mom. She was just 3 year old.
And where did Nayeli live before? So she passed away in December of 24. Where was she living?
With us, home.
And did she live there full time?
Yes,
And had she moved out before that at all, or had she always lived there?
she always lived with us.
Okay. And what can you tell me about her? Did she graduate from high school?
She graduated from high school. Yes, she go to university she wanted to be a nurse.
Okay. And how did she do in high school? Good grades? Okay.
Good grades.
And how was she doing in nursing school?
Actually, she's doing good. She take this program from technician program also. She graduated from Auburn.
Okay. And she was going to Kent State, the nursing program?
Correct.
And what kind of relationship did she have with you and your wife?
She was very close to us because she's our girl. She was she got close to us a lot.
And what type of things, what did she do around the house or did with you and your wife?
She helping us a lot at home. She do his duties at home and basically also a lot of homework from his college.
When you say she did her duties around the house, what do you mean?
She helping with cleaning the house, helping with mom, cooking.
When you say mom, you mean your wife?
Yes, yes, sir.
Okay. And cooking?
Cooking, laundry, cleaning.
Now, when she was going to get her nursing degree, going to school, was she also working?
Yes, sir.
And where was she working?
She worked in a clinic in Manor, and also she do some part-time in the restaurant.
It's the restaurant you and your wife own?
Yes, sir.
And she did work as what, a server?
Yes, sir.
Okay. And after this accident occurred, how did it affect your wife?
That continue affect her a lot to the point she don't want to come here.
And has she had a difficult time coping with that?
Yes, every day.
And did Nayeli, I think George told me that she had other siblings?
Yes.
And what type of relationship did she have with those other siblings?
Basically, she was babysitter her sibling Mia. She was 5-year-old when this happened.
So she helped babysit Mia?
A lot.
Okay. How about her relationship with Ivan?
They very close. They almost like twins.
Okay. And when you say they were very close, what has, or strike that, how about her relationship with Eric?
With Eric, because when he was, I can say close, but Eric, he got married and he moved out from home, and he doesn't close enough with us.
Okay. So, as far as like Ivan and Mia, have they expressed what they felt that they lost when she passed away?
Sustained.
Have you seen or observed their emotions or as a result of her passing away? Have you observed anything?
Normally with Mia, when we have some family reunions, she go some corners and she start crying, and someone approach her. He say, "What happened, Mia? Why you crying?" She say, "I miss my sister. She has to be here." And I say, "Oh, Mia, that's so sweet." And she just cry by herself. She don't show up his emotion with us that much, but when she is with more friends and cousins, she start expressing the loss.
And what have you observed from your wife?
Since that day, she's crying every day. That changed her life a lot. She's not the same.
In what way, Miguel?
Emotional. I can say physical. Now she getting some medical issues with his pressure. Now she's gonna go to doctors often now, and doesn't like that before.
Depression?
I can say yes.
And did she have to see a doctor before this accident?
No.
What have you observed as far as the atmosphere in the household since her passing?
Basically, it's sad to stay home. We want to go out because we feel like a sad place, and also we have our family. They don't come over because they say, I want to go and visit you guys, but that house made me feel sad. and we get it because we feel the same way.
I have nothing further, Judge.
Thank you. Mr. Kronkel?
Thank you very much. Good afternoon, Mr. Gomez.
Good afternoon.
I just wanted to express my condolences, my client's condolences for the loss. It was a horrible event, and she does feel true remorse about what
Objection.
happened.
How she
Oh.
feel?
Go ahead, ask a question, please.
The restaurant that you have, is it just you and your wife that own it?
Yes, sir.
And do some of your other children work at the restaurant too?
No.
Just Nayeli?
Just Nayeli and, my son Ivan, when he comes to vacation, he do some part-time some days.
Okay. Did you and your wife start the restaurant?
We and a friend of us,
Okay. When Nayeli was there working, did she have any management responsibilities in terms of running the restaurant at times if you weren't there, closing the restaurant, handling the money, and so on?
no,
No. She was just a server at times?
correct.
Had you ever talked with her about possibly taking over the restaurant sometime in the future if you and your wife retired?
No, she has different plans.
Okay. Was there any plans for what would happen when you finally retire?
No, her plan was all the time be a nurse.
Okay. All right. Thank you very much. Nothing further on.
Can you redirect, Mr. Zuccarelli?
No, Your Honor.
All right, sir, you may step down. You can stay here if you want to go out in the hallway. You can stay in the courtroom if you'd like, or you can go back in the hall, whatever you'd like to do.
Your Honor, again, I don't know if we need another hearing, but I think before we can talk about any punitive, you'd have to find compensatory. So as far as that, I have no other witnesses as far as compensatory damages.
What are you saying, not to have another hearing?
I don't know. I mean, I don't know if you need to bifurcate or not for damages. Because I know that under the survival action statute, again, you can award twice the amount of
No, we're gonna hear it out today.
okay, thank you, Your Honor. Then I would call myself, only because under the punitive damages award
You talking about for attorney fees?
for attorney fees.
I'll let you make a statement after that.
Okay.
Let me put you under oath. Raise your hand. Do you swear this testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, go ahead.
My name is Mark Ciccarelli. My business address is 9342 Regency Woods Drive. I am in my 47th year of practice. Normally, this type of case, we would charge a contingency fee. But if this was based on an hourly rate, my hourly rate is $500 an hour. And I would only indicate that this court has the ability to award damages, punitive damages, and under the punitive damage statute, just find that, Your Honor, it allows for those damages. That's under the survival action. And it's also under compensatory. And what the court said in Rubeck versus Huffman, the 54 Ohio State 2nd, 1978, is this court may award punitive damages caused by a ruthless, wanton, willful, and gross acts of malice inferred from conduct and surrounding circumstances. What I would suggest in this case, Your Honor, is that what we had to do, which I thought was completely unnecessary and incurred attorney fees, was the fact that we had a default judgment. We had a notice of appearance in September, and then we had a motion to vacate in November, 2 months later. And it didn't say, and I hear today that counsel was saying he was just trying to vacate damages, but counsel was very well aware that there was a damage hearing set. You had not issued any damages. So the 6dB motion to vacate, the only thing that it could have vacated was the default judgment that found liability. And of course, in order to vacate under 6dB, you have to have a justifiable defense, and there can't be a justifiable defense because she pled guilty and admitted it. So to come today to say he was just trying to vacate the damage hearing, I think is somewhat disingenuous. That necessitated filing a response to that. There was another response filed by defense counsel, a reply brief. There was a motion filed by defense counsel to obtain discovery. There was defense counsel's briefs being filed in this case that I had to address today, which talks about under Huffman, in order, we would have to prove that she either was alive and sustained damages, or that she had an ownership interest in the damaged property. And he indicates, defense counsel indicates, if she owned the property, then she's entitled to punitive damages. And what's so frustrating is, State Farm, who defense counsel's here on behalf of, knew in June of 2025, because they wrote a letter. They knew she owned the vehicle. It's the same VIN number as this title. And to come in here at this point and file briefs becomes very disingenuous and makes defense or plaintiff's counsel have to work extra hard for no reason. Because clearly, that was June of 25, State Farm. So it's certainly disingenuous that he would file an affidavit and has indicated today that she put a value on there. That is inadmissible testimony. There's case law that an owner of property can testify as to its value. There's no appraisal here. And then, as the court can see in the last exhibit, which is a court document in case 25 CV 806, which is, this is the document, and I believe defense counsel makes reference in his pleadings how her father was handling her case. That's part of his pleadings in the 6dB motion, that her father was handling her case. Yet, attached to this, he attaches that there's an agreement that she has to pay $300 a month to her dad, and yet in that other court case, 24 CV 806, there are pages of $300 payments by Ms. Matovich to her father, Philip. These are court documents. These are in the file. So for her to say that she had only $1,000 that she paid her father is certainly false. So when the court looks at punitive damages, again, it necessitates more work on my part to have to do the research to all of this, as defense counsel has indicated that you can only provide punitive damages to an individual if you do it, up to twice the amount of the compensatory, or 10% of her net worth. So defense counsel has indicated that her net worth is only 125,000, so that you can only issue damages of 12,000 as punitive.
125,000?
Based on, I believe, the time of the accident, I had a net worth of 125,000. That's what her affidavit says.
I don't believe so, Your Honor. I think it was around 74,000.
Yeah, I thought it was 74,000.
I thought that's her debt. If
No,
you
that's
look-
her net worth.
Number 4. If you look at her affidavit, number 4,
Yeah, what did I do with that?
I have it.
I have it right here.
Paragraph 4. Of her affidavit,
Yeah, that's another one.
Exhibit A.
You know, I think she just did the math wrong.
Oh, I see what you're saying.
Well, whether she
Then
did
number 4, it says based on the above information, she's saying her total debts were 74, total
Right.
assets are 199.9, net worth 125. Yeah,
Okay.
it does say one. I know in your brief that you kept writing 74, but those were her debts, according to this affidavit.
So that's what it says in there. Again, which necessitated further work to go through everything and find that, in fact, what she wrote was a lie, because she paid more than $1,000. I'm certainly not blaming defense counsel because she filled in the blank. But, again, this isn't something that's hidden. This is a public document that was filed that defense counsel indicated her father handled her information and was well aware of the other case. This is a case, I'm telling you, this is a case, State Farm needs to be punished. They have fought this case for no reason. They have tried to vacate something that they couldn't vacate. You know, we have a case that this lady's probably not very collectible, but I have had to spend probably 35 hours having to write briefs, having to do research because of filings that were not appropriate in this case, and finding that the information provided by defense counsel was inaccurate. And it is certainly a case that cries out for punitive damages, presuming you find compensatory damages that she sustained, that she's been damaged, and I think that it would be hard-pressed not to find some compensatory damages based on the fact that this lady was drunk and killed this poor young girl who was in nursing school. So anyway, as to the attorney fee part, having to do all of this extra, but I had to talk about these motions and supplemental briefs that are inaccurate. I think 35 hours times $500 would be the attorney fees that I think would be appropriate for the extra work that had to be done. Thank you.
Thank you. Well, Mr. Crum will ask you questions if he wants to. You can sit down though.
Do you have a copy of the contract with the Orozco family? Your fee agreement?
Yeah, I do.
Can I see that, please?
I do not have it with me. I don't have that part of the file. I can assure you, testified under oath, my contract with the Orozco family is 1/3 and 40% if we went to trial.
Is there any place in your contract that you listed a fee agreement of $500 per hour?
Absolutely not.
So your fee would be 1/3 of whatever was collected, right? That would be your fee agreement with them.
That would be my fee agreement as between my client and myself. I'm here testifying as to punitive damages because of the actions of your client, the insurance company. That's the reason I'm testifying.
All right, yeah, question, next question.
And is there any document you have which shows that your standard rate is $500 per hour for this kind of work? Do you have any documents with you?
I can testify as an officer of the court that in all of my cases, I charge $500 an hour unless it's a criminal matter, which is a flat fee.
I guess you asked if you have any documents.
I do not have any documents here.
Do you have any documents showing the time that you put into addressing the briefs that you believe you have written because of my filings? Is there a time listing or a log of your hours, dates, and times that you put into addressing these briefs?
I do not, because I was not going to charge my client.
Did you do all the research personally, or did one of your assistants or associates do the research?
I do all the research
You do all the
myself.
research yourself?
I do it all myself.
And did your assistants or associates help you to put in, to assemble the briefs that you claim that you have written?
First of all, it's more than briefs. It's also looking at the document you submitted. But to answer your question, the only thing that my assistants do is type and staple the documents and e-file, because I don't know how to do that. They do none of the research, none of the writing.
But you don't have any itemization.
I do not.
You knew that you were going to be asking for attorney's fees from a long time ago, because you made a motion for attorney's fees probably 2 or 3 months ago, but you didn't bother to catalog your time you put in. Is that right?
Yes and no. As far as this hearing, I did not put it in under the motion for frivolous attorney fees. You're entitled to a hearing on that, and I would have put it together. I was not expecting this to be the frivolous motion here. This was just the attorney fees under the punitive damage section.
Well, the attorney's fees that you're talking about under statute, that would be fees in connection with representing your clients and your contingency fee, right? We're talking about two different things here. We're talking about attorney's fees that you believe you're entitled to as part of the punitive damage.
Hey, I want to interrupt for 1 second. It wasn't my intention that this was going to take the place of the hearing on that motion. I'll still do that. That was
Okay.
for, if I'm remembering correctly, you filed that motion as a result of
The 60B motion.
the 60B motion,
Yes.
you having to respond to that, and you filed that then. And
I did.
that's still pending.
Okay.
This, today, is just a part of punitive damage claim in which you'd be entitled to, if I award punitive damages, a award of attorney fees for handling the case.
In handling the case with my client, I have a retainer of a third, and 40% if it went to trial. I suppose this would be considered trial for that aspect.
Go ahead, Mr. Cromwell. So that's still pending. But that's
So
the
other-
frivolous action that you're alleging by the defense counsel is for this. It's the 60B motion
Yes,
that was filed.
I stand corrected on those then. Thank you.
Your 40% in the event of trial, that would be justified because if you went to trial, you'd be spending time picking a jury, putting out evidence, putting on witnesses, making closing arguments. You're talking about a process that would take 2 or 3 days, right?
I think I just put on witness today. I put on testimony today. So, yeah, I think this is a trial.
And if there is a recovery, well, there's been an offer of insurance money, so if there is any more recovery, your fee would be 40% of that or 1/3 of that?
It would be 40%.
I don't have any further questions, John.
All right. Let me see. All right. On behalf of the plaintiff, anything else you wish to present?
Your Honor, I have nothing further other than the submission of my exhibits.
Any objection to any of the exhibits? I know your position on the funeral bills expenses, but I'm going to allow
Funeral
those.
bills, again, Exhibit 3 is really a hearsay document, not here on behalf of State Farm, but they are paying my fees, but I would object to Exhibit 3. The remaining, and I don't know what Exhibit 1 is, but that's been presented to court.
There wasn't any issues as to her debt, so I did not present Exhibit 1. I'll withdraw that if that's easier.
Maybe we'll just take that out then. Well, are these court's exhibits here?
The originals are up here on the
Oh,
bench.
you have some there?
I don't
Yeah.
have any. There's some up here.
We can,
Those were yours to follow along with, Judge.
so what's that up there? The same packet?
Same packet, just originals.
Well, then take out one number 1 and give it back to Mr.
I did not put number 1.
Oh, you
in.
did. It's in this one. Okay.
It's just, I had given you a packet ahead of time
Right.
so you could follow. The rest of them should be up there, except maybe, I think I,
Do you know how many, is it 2 through what?
2 through 12.
What about 11?
I
I don't have 11, which,
11 is out too.
right.
2 through 12? Or one is it?
I got 2 through 10 right here right now.
11's out,
11's out, okay.
and 12 I testified to.
Okay, so we put 12 in here. All right. You got everything. Okay.
So 2 through 10 and 12. Correct?
Yes, Your Honor.
All right. Mr. Krondel, any evidence you intend on presenting here?
Your Honor, I do have some exhibits attached to my pleadings. I had wanted to either read in the record or offer an apology letter to my client. I recognize it's not a criminal sentencing hearing, but I don't know whether the Roscoe family had an opportunity to at least understand her apology about this.
It has nothing to do with this, though.
Well, if they're willing to accept it, I'll let them, their attorney decide if they want to. She did write a letter of apology, which I can offer as an exhibit, but other than that, I just have the exhibits attached to my various.
Well, I'm not going to have the letter be part of this, but let's just make sure we're on the same page then. I have your damage hearing brief. I don't think there was any exhibits on that, but then there were exhibits on the supplement.
There was just the affidavit of Mr. Sweetlet.
I have that. Well, that's a separate filing. I have that right here.
And in
And
my
then-
supplemental, I think I just have A through E.
Okay. All right. All right, then, Mr. Zuccarelli, out here, any closing?
I would just object to A, which is the affidavit of the defendant in this case, which A, I can't cross-examine, but by my Exhibit 12, have shown that that's incorrect.
Well, I'll give it whatever weight
Yeah.
in light of your exhibit too. And you, Mr. Cronville, your brief, you referenced that she said it was 74,000.
Yeah, that's my mistake, Your Honor. That's my bad math, and I apologize. Actually, the assets minus liabilities would be, and she may well have done that, and I didn't put that.
No, it sounds like she did it right. You did it wrong.
I might have done it wrong. I'll take responsibility for that.
And she
So-
said her net worth is
Yeah, that's
25.
an error on my part.
You just used their debts as the
Right.
number.
Well, I was looking at the wrong line in the brief, and I'm apologizing
That's
to counsel and to the court.
Fine.
As far as what she's paid, I'm not really sure that matters at all, because it doesn't go towards calculating her net worth.
But it goes towards credibility if you want me to accept her affidavit.
Yeah, I understand it does, and again, Your Honor, as I explained, she's in jail, she doesn't have access to this kind of information. She
Yeah,
needs
she's-
that.
And then she shouldn't sign an affidavit. I mean, I don't know what to say.
She's testifying on her best knowledge, and that's what she said at the end. If her knowledge is incorrect, then certainly the court can take that into account. As far as punitive damages go, Your Honor, they still have to show.
Hang on, I want to hear
I'm
from...
sorry. Oh, I thought he was done, I'm sorry.
No, he was just objecting to your exhibit
Okay.
first before he...
You know,
Hang on 1 second. All right, go ahead.
Just before we begin, do you have copies of the checks that she had paid? Because I never saw any of that, even when you had shown that.
It's one of the exhibits, isn't it?
The
yeah, it's
account.
on the exhibits 12.
You didn't just give him that?
No.
I think I can give him this one. I mean, I won't need this anymore because we'll have the court stuff. This is just giving me, if that's okay.
Oh, absolutely.
Just come on. I'll just give him exhibit 12. This is the pleading that you...
Yes.
Yeah.
Here's the pleading with all the checks she wrote.
All right, Mr. Zuccarelli.
Thank you, Your Honor. I mean, you heard, first of all, you heard an expert testify. There's no other expert in this case, and under the compensatory damage statute, the wrongful death statute 21-2502, one of the factors of damages is the loss of support from reasonably expected earning capacity. You heard Mr. Medica testify that that number was $862,000, $862,137, uncontroverted. If you take a look at his CV, he's clearly an expert, has testified numerous times. Although defense counsel tried to shake him, if you look at his supporting documents, that number could have been a little higher, as the court pointed out, because the average salary increase of 3.75 is higher than the discount rate of 3.19. I think he was credible. I think that would start the damage. And then, you know, what's the damage for a 20-year-old who's in school, going full-time to school to be a nurse, and not only going to school, but you have W-2s that she's working 2 part-time jobs making $12,000. You know, if you see her grades, she did very well in the nursing program. I believe she was getting A's in that program. If you take a look, she had family who, you've heard her brother testify that he visits her grave twice a month. Those factors under 21-2502 D1, loss of society, companionship, care, assistance, attention, protection, advice, guidance, counsel, instruction, training, and education. What do you put on that for your 20-year-old daughter and sister being killed by a drunk driver? I don't think it would be unreasonable to add another $138,000. I think that would be reasonable for all of the loss that they've had to sustain. I believe that should this court, and I think the court will find compensatory damages, because the parents are rebuttably presumed to have suffered damages, and then other next of kin. And the damages need to be appropriate to the injury and the loss resulting to the beneficiaries. That's what the statute says. I'll let the court, because I'm not that smart as far as the funeral expenses and the other court ordering the funeral expenses. I think that's part of the damages in this case, because my client paid it. That may be a court order that she's obligated to pay it, but I'll let the court make that decision. But that's certainly one of the factors under 21-2502C1. I believe that the court will find compensatory damages, in which case we move to punitive damages that would be allowable under 230521, the survival action, and the Supreme Court case that says that we can obtain punitive damages if there's personal injury or property loss and I believe we've proved that there is property loss in this case. Now, I believe that the defense counsel has conceded that issue, that if we can prove we own the car, and again, I vented and I vented, it's very frustrating that there's an issue about owning the car since it's been known since at least June of 25 that they were going to pay for the damage to the car. You heard that the family was close, that they did things together, that she still lived at home. And I think if you look at that and look towards the punitive damages, 23-15-21 indicates the lesser of 2 times, not more than 2 times compensatory damages, or the lesser of 10% of her net worth. And on attorney fees, there's no cap. My burden of proof is by clear and convincing evidence. I agree with that. And in this case, first of all, her affidavit not only goes to her credibility, but she's not competent to testify when she puts in her affidavit that the value of her house is X. That would be inadmissible evidence because she doesn't own the house and there's no expert here. So even coming up with that number of what her net worth is fallacious. There's nothing there to justify it. If she paid, like my numbers support, if she paid another $8,000, that alone would have increased her net worth. So I mean, her affidavit, I think the court should disregard her affidavit, and if you disregard her affidavit, then you have no evidence here of her net worth, in which case we would ask that the court award punitive damage based on whatever they think is fair. This is a serious case. I think everybody knows that the lady had some prior OBIs. That's why she got sentenced to 12 years. So when you look at those factors and what we've had to fight to come here, this is a punitive damages case. Thank you.
Thank you. Mr. Congo?
Thank you, Your Honor. There's clearly no doubt that plaintiffs are entitled to compensatory damages. As to what that amount is, I will leave to the discretion of this court. My concern is the punitive damages. Plaintiff counsel takes issue with the affidavit. I think she testified as to her best knowledge. I didn't fill in any of these numbers. These were all handwritten by her while in jail.
I wasn't suggesting you falsified anything.
I understand, Your Honor.
Nor was I.
And then you said
Nor was
that.
I, for the record.
All right, just to make it clear, I think she was asking a question, and that was going on the best of her knowledge. I haven't had a chance to examine all of these checks, but just a cursory examination, these were all written in 2011 and 2012. So she may not have a very good memory as to what she paid 14 years later, 15 years later, as to exactly how much she paid her dad. So I think she was going on her best information that she had. As far as the attorney's fees, again, I don't think that Mr. Ciccarelli is entitled to attorney's fees here. Certainly he's done an outstanding job representing his client, but I think this is a case where it's a terrible accident. There's been monies offered that have been rejected by plaintiffs in this case. I've tried to put on a zealous defense for my client. She's of course not able to defend herself while she's in jail. She has tried to apologize to the family, but I think that if there is an award of punitive damages, it should be capped at 10% of $125,267, which was what Elizabeth calculated her net worth is. I apologize to the court because the number in my pleading was incorrect. I don't think that there should be an award of attorney's fees in this matter. I think certainly Elizabeth has been punished a lot for her actions. She's remorseful about the actions. I don't think that an award of attorney's fees is appropriate in this case, and that the court should abide by the statutory caps on punitive damages.
All right, I will take this matter under advisement and then I'll get a ruling issued.
Thank you, Your Honor.
Thank you, Your Honor.
All rise.